Privacy issues of coronavirus and returning to work is a big topic, whether you're a pub, a small office, you're in the public sector, or an international enterprise. While there are specifics that will apply to each organisation, the core privacy issues are the same for all. And stay with us as we'll lead you through completing your DPIA at the same time in 10 key steps. Feel free to pause the video along the way to jot down your first draft. This is a slightly longer video, so it's in 2 parts. In this part 1, we'll go to the source, the GDPR, as well as the UK ICO's 6 steps. We'll also reference the amazing guidance from New Zealand's Privacy Commissioner, highly recommended. Hi, I'm Robert Bohr, the founder and CEO of Keepable, the award-winning solution saving you time, money and stress on privacy, giving you a great answer for the board and customers. This video is part of Privacy Kitchen, free video help with GDPR and all things privacy. If you're new here, please do click subscribe and notify to hear about awesome new Privacy Kitchen videos. Links are in the notes below as always. Now, one certainty about coronavirus is the situation will constantly change. This video was made on 27th June 2020. The GDPR aspects won't change, but do keep an eye out on regulators' guidance, emergency laws for sectors, etc. Now first, let's be practical straight off and kill a big myth with a great statement from the UK Information Commissioner Elizabeth Denham. Data protection does not stop you asking employees whether they are experiencing COVID-19 symptoms or introducing appropriate testing, as long as the principles of the law, transparency, fairness and proportionality are applied. This has been reflected outside the UK in a joint statement from the Council of Europe and the Committee of Convention 108, saying it's important to recall data protection can in no manner be an obstacle to saving lives. It's all about balancing the interests at stake. But you do need to comply with the law, and the UK ICO summed it up nicely there. They go on to say it's all about being proportionate. If something feels excessive, it probably is. And that's reflected in that joint statement, which said employers should respect the principles of necessity, proportionality and accountability, and be guided by principles designed to minimise risk to employees. So we've seen that GDPR does not stop you, and we've seen that there's a nice framework about how to go about it. Stick around, we'll show you exactly how to do it. So the first thing is to recognise this is clearly a sensitive topic. Let's make sure we cover off GDPR's 7th principle, accountability, from the start. I recommend you put all of this into a document, call it a draft data protection impact assessment or DPIA. It'll save time later on. You need to do a DPIA anyway, and doing it this way will make it super simple. You'll also show you've implemented data protection by design and by default. Now, Keepable and other providers have template DPIAs, and the regulators like the UK ICO make them available for free. If you've got a DPO, you're going to need their advice on it anyway, and they will give you your template. The key thing though under GDPR is there's no set form to use for a DPIA. As long as you cover GDPR's requirements in Article 35, and they're on screen now, you're fine. It's the minimum a DPIA should cover. You can see it's obviously what we need to be thinking about in this situation anyway. Number 1, describe the processes, including the purposes. Number 2, assessing the necessity and the proportionality of that processing. Number 3, assessing the risks to individuals. Number 4, the measures to address those risks. Now you could even copy and paste these requirements into a document and use them as headings in your DPIA. Okay, open up a new document, grab a coffee, and let's get started. Now we've already identified 3 frameworks we'll use to look at this. GDPR's 7 principles, the UK ICO's 6 steps, and the DPIA requirements. So this is our first key step for your DPIA. Make a note of these frameworks in your draft DPIA so you can show you've thought about the right things. We've already talked about accountability, GDPR's 7th principle. Now let's set out all 7. And here are the UK ICO's 6 steps. Now we won't follow the strict order of the UK ICO's steps here, but they're correct to start with only collecting what's necessary and keeping it to a minimum, of course. If you don't collect information, you can't misuse it, you can't keep it for too long, or disclose it inappropriately. But necessary for what? So you first need to identify why you're collecting the personal data at all. What's your purpose? And presumably the purpose we're talking about here is to maintain a safe working environment. It's the right thing to do morally, but you'd also be liable as an employer if you didn't under health and safety and employment laws. Now, you won't use this data for any other purpose than the ones you specifically set out. This is GDPR's 2nd principle, purpose limitation, and this is our 2nd key step for your DPIA. Make a note of your purpose in your draft DPIA. Okay, risk assessment and appropriate measures. This is UK ICO's 4th point. We know the purpose now, so we need to flesh out how we're going to achieve that purpose, and we're going to assess the risk to individuals from our processing. Now remember, GDPR just doesn't care about the risk to your organisation, it's all about the individuals. But otherwise, risk assessments for GDPR are very familiar. You identify the threats and vulnerabilities, You look at the risks and then the ultimate damage to individuals. You look at the measures you can put in place, and you then look at the risk and you quantify the likelihood of them happening and the impact if they do, and you combine them together to get a risk rating. Now, a second key aspect of GDPR and risk is you can't move forward with high risk processing without getting advice from the regulator. So you're going to be prioritizing the high risk, which this will be, likely high risk, put in place sufficient measures to mitigate that down to acceptable levels, if not negligible or negate it entirely. The UK ICO gives some great high-level questions to think about here. How will collecting extra personal information help keep your workplace safe? Do you really need the information? Will any tests you're considering actually help you provide a safe environment? Could you achieve the same result without collecting personal information? Can the collection of health information be confined to high-risk roles? And can access to health information be limited so it's only seen by, for example, medical qualified staff, those working under specific NDAs or particular positions of responsibility? Are there reasonable alternative measures that don't rely on personal information, such as strict social distancing or working from home? And as the UK ICO advises, don't look at this at the generic level only. You then need to consider the specific circumstances of your organisation and workplace. Things like the type of work you do, the type of premises you have, whether working from home is possible, any specific regulations or health and safety requirements that apply to your organisation and staff, and any duty of care that you owe to them. Now, don't worry, you don't need to write War and Peace, but you do need to consider the key issues, in particular that risk assessment and the measures in place. As the UK ICO notes, if you can show that your approach is reasonable, fair and proportionate to the circumstances, it's very unlikely data protection would be a barrier. Okay, great progress. We've now identified the risk to individuals, the best way to minimise that risk with necessary and proportionate measures, not just from a health viewpoint or privacy viewpoint, but from a holistic viewpoint. We've dealt with the fairness part in GDPR's first principle, and this is our third key step for your DPIA. Make a note of the risks you've identified, their likelihood, impact, final risk rating after the measures you've put in place to address those risks, and put that into your draft DPIA. We've also identified it's the minimum personal data necessary to accomplish the purpose. We confirm there's no other way to achieve that purpose and minimise the risks that uses less data. And this also addresses GDPR's third principle, data minimisation. And in working out how to collect the data, you've ensured that all forms, if you're using them, are easy to understand, that the data is easy to correct. You've looked to minimise any errors, perhaps with automated collection. So you've addressed GDPR's fourth principle of accuracy. Now, when you've fully considered and answered these, this is our fourth key step for your DPIA. Write down the personal data you need for your purpose, why it's the minimum personal data, that you've looked at other ways, and this is the way to minimise the data you're going to collect. Now, special categories of personal data. That's a reason to be particularly careful when considering all of this, because the personal data you're collecting is health data, which is a special category of personal data under GDPR. There's an even stronger presumption against processing special categories due to the higher risk that they represent to the individual data subjects. So first, here's GDPR's definition of health data. You can see it's obviously data relating to someone's physical or mental health. It's also information revealing information about his or her health status. So it extends beyond that direct information. As long as the information reveals something about their health status, it's health data. It could be an appointment with a specialist and that reveals something about their health. Recital 35 in GDPR gives more guidance, as does the UK ICO's excellent guidance. Right, we're halfway through. This is our fifth step for your DPIA. Itemise which of the personal data you're collecting is special categories and probably health data and which isn't. See, DPIAs aren't so scary, we're filling it up nicely. Now we'll pause at this point and we'll come back in part 2.